How could it be argued that the Constitution is a living document? Perhaps the most significant power wielded by the American judiciary is the principle of judicial review, the authority to examine actions taken by the legislative and executive branches at both the federal and state levels, and to invalidate those actions if they are found to conflict with the text of the Constitution. This power is not explicitly granted in Article 3 of the Constitution. It was decisively established by the Supreme Court itself in a landmark case you may have heard of called Marbury versus Madison, 1803. In a politically masterful decision, Chief Justice John Marshall declared a portion of a federal law, the Judiciary Act of 1789, unconstitutional because it purported to expand the Supreme Court's original jurisdiction beyond what Article 3 allowed. By striking down part of a congressional act, Marshall asserted the judiciary's role as the final interpreter of the Constitution, placing it on an equal footing with the other branches of government. Judicial review serves as a powerful check on government power. It allows courts to protect constitutional principles and individual rights from potential encroachment by elected majorities. For example, the court used judicial review in its Brown versus Board of Education decision, strike down state-mandated school segregation, and in the Miranda case, Miranda versus Arizona, 66, to establish rules protecting suspects' rights during police interrogations. However, the exercise of judicial review is inherently controversial. How should judges interpret a document written centuries ago? This involves different philosophies of constitutional interpretation, which we'll explore in this course. One philosophy could be called originalism, views the Constitution as a dead document. And here it's argued judges should seek the original meaning of the constitutional text, either as intended by the framers or as understood by the public at the time of ratification or in popular understanding. They aim to limit judicial discretion and defer to the text's historical meaning. The opposite perspective, and both these transcend politics, is constitutionalism, living constitutionalism. Proponents view the Constitution as a dynamic document whose principles should be adapted to contemporary circumstances, questions, and evolving societal norms and values. They believe interpretation must consider the broader purposes and principles of the text in light of modern realities, whereas the originalists would say, sure, it's a living document. That's what the amendments process is for. The constitutionalists would say, actually, I can read something new into what this means in our context. We can let the justices almost operate as super legislators, reinterpreting very, very old texts and laws to accommodate a very, very changed people. These differing approaches can lead to vastly different outcomes on contentious issues, particularly Supreme Court cases as it relates to gun control, abortion, and campaign finance regulation, to name just a few.